Great. Thanks very much to the organizers and to my fellow panelists for having me here. I appreciate Tom's your lead-in by speaking about the public mission of the law school, because that's ultimately what I'm speaking about today. The premise of my talk is that law schools, as publicly funded institutions, as dispensers of knowledge about law, which is preeminently a public good, should be thinking about their public mission as a foundation of what they are and on which they're built. I'm going to use the term citizens to signal this concern with the public mission. And I do so both because citizen, I think, requires us to think about the public sphere. But the individual of citizen reminds us of the student as the ultimate focus of the law school's endeavor. So when we think about what type of citizens are the law schools cultivating, we're thinking about in what manner are we trying to form the students that are involved in this enterprise. So I'm not talking about citizenship as a collection of entitlements to which some people have access and others don't, which raises problems of exclusion, very important questions. But when I speak of citizenship, I'm speaking about it in that more limited way. I'm not going to talk today about a definition of citizenship. I think there are plural definitions. I'll canvass a few later on. What I want to talk about is how the word citizen has been used in relation to the term lawyer. I think we all agree that at least one aspect of the law school is to train lawyers. I think this is relatively uncontroversial. And I want to talk about how the term citizen relates to it. And I'm going to talk about two particular ways. The first is an additive notion, the idea that law schools should be cultivating citizenship in addition to training lawyers. And the second thing I'm going to be talking about is an integrative view of citizen and lawyer, so the citizen as lawyer. The idea that the citizen and the lawyer are mutually reinforcing, mutually constituting concepts. Okay, so I think the notion of citizen as lawyer is a relatively familiar one. It's the idea that the university is bringing something special to legal education. This is a picture of Ernst Freund, who was advising the president of the University of Chicago about whether they should start a law school. The president was skeptical, and Ernst Freund said, no, we should have a law school here because the university ideals will broaden and deepen the legal consciousness of the legal profession. Similar quote to, I think, what Professor Corey spoke about that Professor McLaren told us about. I think this notion of the university adding something special is the source or one of the underlying factors of the fierce debates between the universities and the law societies and the tussle over jurisdiction. And I also want to say something about how the word lawyer and citizen is used by law schools themselves. I found a very interesting quote by the mission of Georgetown Law. I'd like to read it because it says a couple of things. So what do they want all their graduates to do? First, as lawyers, they should be capable of addressing imaginatively and constructively novel problems arising from new institutional arrangements and technologies based on familiarity with the theoretic foundations of legal materials. Extremely aspirational, broad view of what the lawyer is. Secondly, as leaders in the profession, they should enjoy and have the capacity to assess, criticize, and reform laws and institutions. And third, as citizens with the capacity to lead public debate, they should pursue social justice with wisdom, knowledge, and integrity. So even on this extremely broad view of what it means to be a lawyer, they are still saying there's something in addition implied by the notion of citizen. So obviously these are three overlapping identities in each of their graduates. I like the image of acetate sheets in biology textbooks, but nonetheless the notion of citizen is something new, something separate, something additive. Okay, that's one way of thinking about the citizen and the lawyer. Another view is the integrative view. What does this mean? Well, on the one hand, learning to become a lawyer cultivates attributes of citizenship. Conversely, cultivating these attributes of citizenship makes you a good lawyer. I'd like to chart three instantiations of this claim and then talk a little bit about implications of it. Okay, so the first one, and I think the most theoretically developed one, is the concept of the lawyer-statesman. That's a very old concept, originating in the late 18th, early 19th century, especially in the US. And Anthony Conrad in 1995, in his book, The Lost Lawyer, develops this and tries to revitalize this concept. So I'd like to just present what this concept is. Okay, so in what way does training lawyers cultivate good citizenships? In two ways. The first way is it cultivates the skill of practical wisdom, which he says is the necessary skill we need in our public debate. Our polity is constituted by competing moral and other values, the resolution of which cannot be done mechanically, which requires a degree of wisdom and the capacity to deliberate among incommensurable goods. So practical wisdom is inculcated by law schools. I'll explain how in a second. The second thing that attribute of citizenship that law school gives us is a sense of civic-mindedness, or a sense that graduates care about the public good. How do law schools do this? Cronman says through the case method. Okay, so engaging in the case method requires students to take the position at one point of the parties in the dispute. So it requires them to be sympathetic, to enter the shoes or take this perspective of one side or another of the dispute. It then asks them to take the position of a judge and to detach themselves from this partial perspective. And it's this combination of sympathy and detachment which he says is the essence of practical wisdom. So the case method trains this skill of practical wisdom. At the same time, what the case method really emphasizes is the judicial perspective. That's where the emphasis is placed. And he says judges are, by definition, concerned with maintaining the integrity of the justice system. So he says it's an intentional process of transference. Law students put on the hat or the wig or the robes of the judge and adopt this sense of concern for the integrity of the justice system. They care about the public good by definition. Okay, well that wouldn't be an integrated view of citizen and lawyer if he didn't run it the other way, and he does. So, what does he say? He says, the virtue of practical wisdom is actually necessary to be a good lawyer. You have to help your client deliberate among various goods and various ends. It's not just providing a list of options to get to a predetermined end. You have to take the position of your client, be sympathetic to your client, but at the same time be detached and give good advice. Secondly, he says, in order to be a really good lawyer, a good advocate, for example, you have to not just be able to ape what judges do, but really appreciate what they do, anticipate what they're going to say. You have to be a connoisseur of law or a connoisseur of judging. And you cannot be a connoisseur of something unless you appreciate the internal goods of the thing of which you're a connoisseur. So you actually have to appreciate the internal goods of the justice system if you want to truly anticipate what judges are going to say and use that to your advantage in the case of advocacy. Okay, so I'd like to highlight a couple of other places where these notions of practical wisdom and civic-mindedness have also appeared. I spared Professor Arthur's the indignity of a photo of himself. But this is a quote from 1983 in Law and Learning, where he articulates at the beginning of the report one definition of what lawyers could do. So, one thing lawyers should be able to do, or he asks whether law schools do this, to offer wise counsel in the social and economic implications of the legal problems to adapt to changing laws and client needs. This looks a lot like practical wisdom or engaging, meeting the client, and taking his perspective. At the same time, to assume positions of political and community service and leadership, to evaluate critically and help improve the administration of justice. Again, a concern for the administration of justice and civic-mindedness. That's in his concept of humane professionalism, which some have called an attempt to revitalize the concept of professionalism itself. More recently, in 2007, the Carnegie Report on Legal Education also evidences both elements. First of all, they focus on the official public role of the lawyer. Those admitted to practice assume an official public role. This is part of the designation of all attorneys as officers of the court. In principle, lawyers have the obligations to see to the proper functioning of the institutions of law. Speaking about what the lawyer does, in learning the role of the counselor, the student is also learning a model that puts the lawyer in the role of cooperative problem solver with the client. So again, I think this is an indicia of sort of the practical wisdom that Cronman was talking about, combined with this attempt to inject the notion of professionalism with a sense of public purpose. This is the concept of civic professionalism. It's also an integrative. So I'm using the image of integration. The Carnegie Report is also highly integrative in referring to its main recommendation to integrate the three apprenticeships. The cognitive apprenticeship, that's learning to think like a lawyer. The practical apprenticeship, experiential legal education and clinics. And professional identity apprenticeship, which is professional responsibility, ethics, and a reflection on the professional role. The idea is that all three of these are integrative and mutually reinforcing, which I think evidences this notion of integration. Okay, so this idea of integrating citizen and lawyer is intimately tied to revitalizing or re-enchanting the concept of professionalism. Humane professionalism, civic professionalism, the idea that in becoming a lawyer, you are becoming a citizen, and the two go hand in hand. For the remainder of my talk, I'd like to speak about some implications of this term professionalism, this revitalized and re-enchanted notion of professionalism. Okay, so the first thing I want to say is that this concept of professionalism has incredible promise for a number of ways. The reason why it has the most promise is because it invites us to incorporate concerns about the public good, the notion of citizenship, lock in step with the other drivers of the law school. So we can mobilize the incentive structures of the law school, whether they come from outside, the changing legal services market, the funding pressures, the increased pressure to do practical training, professional responsibility, or whether they come from the inside, the grades, prestige, faculty resources, all of the things that drive what the law school does. We can take all of those and use them to advance a notion of citizenship, to bring us along with reflecting on the nature of public value. Okay, so if it's all in the same package, if it's all under the rubric of professionalism, we can do away with all these old fierce debates. And this is meant to look like a little bit of a happy face, but it's also meant to denote the idea that the university can contribute to the project of defining and, as Professor Susskind used, adding flesh to the bones of the argument that professionalism is the core of legitimacy for the legal profession. So the university can help define what professionalism means and provide perhaps a degree of definition or intellectual weight to this concept on which the legal profession relies. My own call to the bar had someone exhort us to think of law not as a business, but as a profession. And I think the legal profession law associations could benefit from this project of the law schools using professionalism. Okay, so that's the incredible promise of this term. And now I'd like to just address one caveat and then one possible counterpoint. Okay, so if professionalism is going to be the guiding rubric for what law schools do, then it cannot be a thin version of professionalism. Just because there may be consensus about using the term does not mean that we should reduce to a lowest common denominator. And I think this label professionalism can be used to refer to thinner concepts or subsets of a full-fledged notion of public mission. So it can't be a thin version, it has to be a robust version of professionalism. That's the caveat. My counterpoint, or my question now, though, is what might be lost by putting all our eggs into the professionalism basket? And I'd like to suggest that there are some conceptions of citizenship, conceptions that are very close and core to what law schools currently do, that might not be as fully explored by limiting the ambit, however broad that ambit is, to the question of professionalism. The claim is not that none of these elements of citizenship will fit within the concept of professionalism. It's that they might not be pushed as far as they can be, and extreme or limits of that concept will be incompatible with the concept of professionalism, and I think that will constitute a loss. So I have 4 quick examples. First is the notion of critical thinking. Socrates, encouraging us to question the underlying premises of our ideas. Martha Nussbaum talking about critical thinking helping us to become reflective critics of traditional practices. So to truly question the underlying premises of the legal system and the justice system, I think at its limits, might be considered somewhat heretical and counterproductive to the project of building up a concept of professionalism. So I think there's a danger there. The second, and this is meant to be a political spectrum, a country music political spectrum. I didn't know if that would play well in Alberta, but I thought I'd try. But the notion that law students should be developed some degree of political consciousness. And we have people like Duncan Kennedy in his famous hierarchy article actually arguing that the purpose of legal education could be to establish the groundwork for a communist revolution. It doesn't only have to be in the left-wing side of the spectrum, but perhaps also on the right end of the spectrum, certain far extreme libertarian views might be seen as incompatible with the notion of the profession. Anthony Kronman explicitly says that revolution is incompatible with the lawyer-statesman view. And so the question is, do we want to ab initio reduce the bounds of the political spectrum to which students would be exposed in the law school? Policy analysis, I think, is incredibly important element of legal education today. The idea, especially in law and economics, where you can take an exogenous perspective and ask what are the implications, the policy implications, the economic implication of legal rules and legal choices. When you speak with law and economics and ask them why they love it, they say, because I can tear away what the judges are saying and I can get at what they're actually doing. Well, what the judges are actually saying and the qualities of legal reasoning and legal language, I think are pretty core to what the legal profession does. And so I think you'd have some policy analysis, and the image of the citizen as a policy thinker or a policy innovator, I think, wouldn't be as emphasized as strongly in the law school if we exclude some of those exogenous perspectives. And here's Rod MacDonald, and he writes about the notion of the legal agent, or law schools helping us understand law in our everyday lives and helping to see how formal rules can help us understand the normative features of our everyday lives and informal settings. I think this is also a concept that would be marginalized or sidelined. Okay, so just to summarize, professionalism has great promise, but if we're going to use it, it has to be the robust concept of the term with a full investment of the notion of public purpose, and relying on professionalism alone risks sidelining and excluding certain notions of the citizen. This is a slide of Thurgood Marshall and Martin Luther King Jr. Thurgood Marshall, of course, worked his entire career within the legal profession to advance the cause of civil rights, Solicitor General and Supreme Court Justice, made great strides. Martin Luther King also was extremely influential advancing the cause of human rights, but he did so through civil disobedience, through the express repudiation of law, and the critic that the state was not standing up to its formal or stated ideals. Martin Luther King Jr., I think, is an image of someone working outside the system, and Thurgood Marshall, someone working within the system. I think this is a timeless tension. Any way we want to achieve a social end, there's always this tension. And I think what we don't want to do is foreclose or exclude the possibility of one of these. And I think the notion of citizenship as distinct from a notion of professionalism leaves room for perspectives from the outside to inform what we mean by a public mission. And if that really is our goal, then I think we would be wise to retain both modes. Final slide, courtesy of W.P. Kinsella via Patrick Swayze, the notion, if you build it, they will come. A lot of what we are focusing on, I think, are the outputs of what we want our law schools to be and to become. And I think I'd just say that you rarely achieve anything great by focusing on your desire for commercial or market success. I think it's usually the other way around. I think what law schools have to focus on is what they can build and do the best job they can at building something great. And I do believe that a focus on the public mission and a broad and plural conception of citizenship will help us build that mission. Thank you very much.